All right. Any other changes or guidelines,
No
challenges?
other additions or corrections. I do have scoring challenges, Your Honor.
Okay, go ahead.
With regard to PRV 5, that was scored at 10 for 3 or 4 misdemeanor convictions. When I review defendant's record, I'm counting at least 8 prior misdemeanor convictions, which would bring that to 20.
All right, Mr. Gilbert, your response?
Well, Your Honor, I would go to the Department of Corrections because I did go and check after the prosecutor brought that up, and they verified that their number was correct. So I was.
Yeah, well, let's see. I'm looking at the adult history. So no security doesn't count. Plate doesn't count. No security doesn't count. MIP doesn't count. No ops doesn't count. Attempted larceny, that's misdemeanor 1. Offense 6 of 23. No ops doesn't count. Number 8 of 23, possession of marijuana, that'd be misdemeanor 2.
Your Honor, I would withdraw that
Okay.
challenge. And then I do have challenges to OV1, aggravated use of a weapon.
Okay.
The offense narrative in this and the police report indicate that defendant possessed a glass bottle. One of the witnesses informed authorities that he threatened to slit the victim's throat. The victim later sort of seemed reluctant to say, but did later state that he did threaten to cut her with the bottle. Did ultimately throw the bottle, hitting her leg, causing a bruise. There is People v. Lang, 25 Mishap 247, that states a glass mug could be counted as a weapon, cutting or stabbing weapon for scoring OV1. So I would argue that OV1 with those facts should be scored at 15 points, Your Honor.
Mr. Gilbert, your response?
Well, I would go back to, and granted, I wasn't prepared for the challenges, and Mr. McClellan did say he was going to challenge some of the OVs just prior to court. He did tell me that. However, I don't believe it meets the requirements, and I agree with the way it is scored, that by it being tossed at her or thrown at her was not a weapon displayed or implied for purposes, and also for the victim was touched by any other type of weapon. I don't believe the actual touching took place to score either 5 or 10 points.
Well, I'm not going to score it for, I think, a slightly different reason. I think it's a McGraw issue. The sentencing offense is possessing methamphetamine in the car. The small amount of methamphetamine that was found during the traffic stop. There's no indication that the possession of methamphetamine occurred, that he used or possessed a weapon during the sentencing offense. So under People v. McGraw, I don't think I can score that conduct. So OVs 1 and 2 will remain at 0 points. Any other scoring challenges from the people?
Your Honor, the only other one then would be OV12, contemporaneous felonious acts. People would argue that the facts just stated with regard to the glass bottle would be a felonious assault that occurred contemporaneously with the sentencing offense, which would bring OV12 to 5 points.
Okay, Mr. Gilbert?
And then I guess I would argue that that he pled to the possession, and that no other felonious activity would have taken place pursuant to our plea.
All right, well, the under OV12, it's contemporaneous felonious criminal acts. And here it's alleged that there was one contemporaneous felony act involving a crime against a person by throwing the glass bottle at a person during a threatening and assaultive situation that did occur within 24 hours of the sentencing offense. It's in unchallenged portions of the pre-sentence report. So I find by preponderance of the evidence that there is sufficient basis to score that. OV12 will be scored at 5 points. Any other scoring challenges from the people?
No, Your Honor.
Okay, that would bring the total OVs from 0 to 5 points. This is on class D.
There's no change.
Okay, so that'd be it'd still be a level 1. So the range would still be 5 to 23. Okay. All right. So Mr. Gilbert, anything you want to say on behalf of your client?
Your Honor, I think the young man that's standing before you has actually understood that what has brought him here. I mean, and him and I have talked prior to today's court via telephone, and then again before today's court. And with his sentencing, he understands that the road that he's on is causing him to be in jail now almost nonstop. Prior, while this case was going on, he's been in the Alpena County Jail. And also, and as he went through the things, he was going through his prior record with me, and he's going drug related, drug related, drug related. I was on meth here. I was on meth here. I think he's acknowledging that that path is causing him to have these felonies and all this jail time. While he's been incarcerated, he has been doing counseling, and he has gotten certificates of completion, numerous ones that it appears that he's generally trying to grab a hold and change his life around. I mean, his record is by no means stellar, and he understands that. And I asked him what he's planning on doing once he gets out. And he does seem to have a plan that he's going to go work for family members and try to get his life in order and continue on with a form of sobriety and addressing his drug addictions. And I hope that's accurate. He seems genuine in his resolve to do that. And I would ask the court to follow the recommendation. Thank you.
Do you know when has he been sentenced in the Alpena matters?
Yes, he has.
What date was that on July 21?
Yes, Your Honor.
Just a week ago?
Yes,
What sentence did you get?
I got a year, Your Honor.
Okay.
Your Honor,
Yeah.
our understanding is that was 2 years probation. With, I believe 1 year jail.
Okay, yes. All right, Mr. Rickaris, you don't have to tell me anything today, but is there any statement you want to make?
I'd just like to apologize to the courts and everybody that cares about me. I could do a lot better than this, and I will.
Okay, thank you. Mr. McLennan, any recommendations from the people?
Yes, Your Honor. The plea agreement in this case calls for a county cap. I think under the circumstances, that's a huge benefit to the defendant here. During this case, he did abscond on bond and a bench warrant was issued. This case obviously involves substance abuse issues. He failed the Alpena drug court program in 2016. He has a fairly extensive criminal history. The PSI indicates 6 felonies, 22 misdemeanors. Many of those are traffic offenses, and he's only 30 years old. Just noted was just sentenced to Alpena for another substance abuse case. And given those facts and circumstances, Your Honor, I think full county cap would be appropriate. Thank you.
Thank you. Well, Mr. Rickaris, you do have not a good history as outlined by the prosecutor in the pre-sentence report, and it sounds like you're fully aware of that. You've previously had the Department of Corrections boot camp program. It sounds like you've had treatment court, so people have tried a lot of different things, which is why then this is a case that, it sounds like there's a lot going on that led to the police contact, but you're not convicted of those things. What you're convicted of, and what I'm sentencing you for today, is possessing a small amount of drugs in a car during a traffic stop. That usually doesn't result in a straddle cell guidance, right? But because of your record, if you jaywalk, you're probably in danger of going to prison, right? Your guidelines are just going to be high no matter what you do. That's not unfair, right? We ought to treat a first-time offender differently than a repeat offender. That seems to make sense. But we do have to also keep in mind what we're sentencing Mr. Rickaris for, and we are sentencing him for possessing a small amount of drugs in the car during a traffic stop. I think the recommendation from the Department of Corrections is within the advisory guidelines. It's within the sentencing agreement of a cap, and it seems proportionate to the circumstances of the offense and the offender. So I'm going to order that you serve 8 months in jail. I'll give you credit for it. Looks like by my count, you're entitled to another 21 days credit. So 172 days credit. That's the sentence of the court. If you wish to appeal, you can file an application to the Court of Appeals. If you want a lawyer, you have to ask me within 6 months. We're going to hand you a piece of paper explaining those appeal rights and ask you to sign a copy for us. The other one is for you to fill out if you wish to take an appeal. Good luck to you, Mr. Rickaris.
Thank you, Your Honor.
Oh, yeah, and I'm sorry, there's also $68 in state costs, $130 in crime victims assessment, and $350 in court costs. The Attorney General here will call People v. Manson.
I'm not. No, so go back to that. There we go. All right.
All right, so let's call People v. Manson Stoneham, 25-93369H. And this is here for an arraignment. Mr. Vogler, you had contact with Mr. Stoneham?
I did, yeah.
Okay.
Just late last week.
Okay.
I expected him to be here, so it's
Okay, Ms. Messer, good morning to you.
Good morning, Your Honor.
We're here for arraignment on Mr. Stoneham. He's not here this morning. He has been in touch with his lawyer. He had a case that just resolved last time I was here, and he did not have any failures to appear. I suppose, second. So I suppose, Mr. Vogler, we could put this on the September 8th for the arraignment at that time. And Ms. Messer, if your office wanted to submit a show cause for Mr. Stoneham to show cause why he didn't appear, I would sign that. If you don't want to bother doing that, what I'd say is if he doesn't show at the second set one, I would just issue a warrant at that time anyway, show cause or no show cause. So that's up to you. But Mr. Vogler, we'll just put that on the September docket, and September 8th at 9 a.m.
Your Honor, that's fine. Kids very easily show up late or something today. I don't know, but
Yeah, but the problem is then that it's being handled by the Attorney General's office,
Right.
and I don't want to have them inconvenience waiting around for a defendant who's not showing up for court.
right.
So if he does show up, I certainly wouldn't hold him in contempt. But we'll do it September 8th. It's on a failure to pay child support. He's been here on some other cases where he frankly was even in more jeopardy than that. So I don't have a concern about Mr. Stoneham's not participating in the case. All right, anything else that you want me to do today, Ms. Messer?
No, that's perfect, Your Honor. Thank you so much.
Okay, you have a good day.
You as well. Thank you.
Mr. Vogler, you've got Raymond and Mr. Hoffman. Is he down in the jail as well?
Yes.
All right, Mr. Darga, are you Mr. Darga?
That's Mr. Dart.
Okay, can you see if the jail can switch you out for a minute with Mr. Hoffman?
Yes, sir, we'll do that right now.
Okay, thank you.
Mr. Garga?
All right, I've received, this is People v. Sean Hoffman, 25-93368FH. I have received the demand for preliminary examination transcript that I have signed. And are you Mr. Sean Hoffman?
I am.
All right, Mr. Vogler, have you had a chance to review the charging document with your client?
Your Honor, I sent Mr. Hoffman a copy of that. I don't know if he has reviewed it or not. Frankly, he doesn't communicate back to me very well.
Okay.
But
Well, Mr. Hoffman, let me ask you, have you been given a copy of the charges against you?
Yes, sir.
Do you wish me to read those charges into the record for you today?
No, sir.
Okay, and how do you wish to plead those charges? Guilty, not guilty, or do you choose to remain mute?
Not guilty.
Okay, we'll enter a plea of not guilty for you as to those charges. Mr. Vogler, is a forensic center referral requested?
No,
What's the estimated length of trial?
I would say 1 day.
Agreed.
Okay. All right, we'll schedule this for a docket call. Well, okay, do you want me to put this on the October docket? Because I just signed something for the transcript to be prepared by September 11th, and September 8th is
Yeah.
when I'm here.
Yeah.
So we'll set this for a docket call October 6th at 9:30. And Mr. Hoffman, that's to allow Mr. Vogler to obtain and review the transcript of the preliminary hearing and see if there's any motion that he needs or wants to file about the case based on that. We also today have a defense motion for a bond reduction. Mr. Vogler, go ahead.
Your Honor, I don't have much more to add to what I've said and provided to the court, other than I guess I would just emphasize that Mr. Hoffman will release. He will be remaining in the community, staying out at 2290 US 23 South, where he was living at the time of this arrest. At this juncture, the 75,000 cash assurity is simply not something he could make. He doesn't have many assets really to make any high bond at all.
Thank you. Mr. McLean?
If I may,
Oh,
Your Honor.
I'm sorry.
Yeah, Mr. Hoffman doesn't have much in assets, also nothing tying him to this community. As soon as the lights of the state patrol vehicle turned on, he ran, Your Honor. He is absolutely a flight risk and a danger to the community. He was flying through downtown. We asked that the bond stay the same.
I mean, some of those things are true, you know, every time there's a fleeing and eluding charge, it means that the lights turned on and they didn't stop. But when I look, there's a habitual notice in this case. Mr. Hoffman is alleged to have engaged in some particularly dangerous driving in this case. He has an extensive felony record and a criminal history in at least 2 counties other than this county. So I think there are some concerns about danger to the community and risk of flight. So I think bond being set at 75,000 cash or surety sounds reasonable. The motion to reduce bond is denied.
Thank you, Your Honor.
Okay, Mr. Hoffman, I'll see you next in October, sir.
That just leaves me with Carol Polyandra, but I wanted to be.
Yes, she's
Coming
gonna
up.
be brought up. We can just bring her up next time. Right, and I'll, is there a Joshua Pritchett present? That word. I did receive, or the court staff did receive information that Mr. Gilbert is not able to be here today. And so his matters, Pritchett and Key and Krajewski, we're going to just put over to the September docket. Any objection to that, Mr. McLean? Oh, and we are providing public access